future. Call me, 310-777-6777, or shoot me an email, donald@f3assetmanagement.com. And don't forget to catch the Family Man's Faith and Finance Show Mondays at 3 o'clock on KCAA Radio.
You're listening to an encore presentation of this program, KCAA, the Inland Talk Express.
Well, good afternoon, ladies and gentlemen. I'm going to try a couple of things different today. Gary's going to be surprised because I got here just on time and we didn't get a chance to chat beforehand. But people who get in touch with me have questions. I try to narrow them down and respond to them on the air so that they get the information that they're really looking for. You know, part of our program, of course, is to provide information. And all of you, well, almost all of you, are lay people, so you don't know a lot about the legal terminology and what to expect if you're in a courtroom. And since most of you will probably be exposed to small claims as opposed to, you know, a substantial litigation in the regular court, I'm going to kind of focus on that for the moment. And in the second half of the show, I'm going to talk about something very interesting because people are asking me about it all the time, and that is, what do you do if people are saying bad things about you? We started to talk about that last week, and Gary asked the question, if I said I'm going to kick your ass, is that going to be enough? Well, it depends.
Oh, you know how many people's asses I want to kick right now?
You'd be very busy. You're going to have to, you know, tighten up those calf muscles.
Oh, I'm strong enough. Believe me, I've been hitting the heavy bag lately to let go of my frustrations, but it's okay. Go ahead.
Is that the heavy set lady that you're going out with?
Heavy set lady? I don't go out with heavy set lady.
You said a heavy bag.
Heavy. You're good, Judge. You're good, Judge.
I don't know if that's going to fly. I'm not.
You mean a heavy old bag you're talking about?
No, I don't talk about old anymore. Old used to be a subject, but that's not how my anymore.
I've never called a woman a bag. I may call her.
You ever heard that term before?
Of course I have.
The old bag.
Of course, the old bag. Yeah.
Yeah. Well, okay. So
old bag.
So you're not kicking any old people these days.
No,
right?
I never. I always pick on somebody a little bigger than me.
Well, what I'm going to do, I'm going to put you on the spot today, Gary.
Oh, Jesus!
I'm going to give you a case.
No.
I'm going to give you a case, a real case that I heard, and I'm going to let you make the decision as to what I should have done. And we'll see if you're right or wrong. Well, it doesn't matter whether you're right or wrong. I made the decision. So
you made the decision. What the hell did I have to do?
That's right. But I want to do like a hypothetical.
Okay.
And then you can answer, and we'll pause for like 2 seconds and let our audience think about it and see what they would do.
Okay.
Does that sound like a decent proposal?
Whatever you want to do, Judge. You know I love you.
I try to think of different ways to approach each week. I've listened to all 16 shows so far.
What do you think of them?
I love them.
I do too.
I'm going to tell you, even though it's my show or your show or
it's your show. No, it's
whatever,
your show.
Whatever it is.
It's your show, man. I got my own show. I got my own worries.
Okay? Yeah, it's chaos.
It's chaos.
We try to provide order in this show.
That's right.
You're the first half, and we're the second half.
I love the
chaos. You provide the chaos. I come in the afternoon and we talk about solutions.
I love the judge because, you know, I've been building some YouTube videos and, you know, I've had, you know, I have to admit I screwed up a little bit. I admit when I have screw ups, you know what I mean? And I don't know if it was my fault or not, but I'll take full responsibility even if it wasn't my fault.
Well,
but the judge, hold on, I just want to tell the judge. So I just want to tell the story because, I've been in a really rough, I've had a rough, I'd say, week and a half. My brother's very sick and I don't really want to get into it, but just haven't been feeling it lately. I've been getting hit all over the place. And the judge, we had a little, I guess, I wouldn't say disagreement.
Creative discussion.
Creative discussions, okay? And I wasn't in the mood to go through it. And then the judge, what'd you say to me?
I said, take a deep breath and I'll talk to you later.
But you also said about being a judge is that you wait.
You have to listen to everybody.
You listen to everybody.
Oh, you absolutely have to listen to everybody.
I agree.
And that's what I was always found to be lacking in restraining order cases, in the temporary restraining order cases. You only hear from one side.
Right.
I always thought that was unfair.
Yeah.
It is unfair. I'm not thinking it's unfair.
It is unfair because you don't know if somebody's doing that to be vindictive or, you know, in my case, and we brought this up on the show where my ex-wife thought I was on her patio on a Friday night when I was...
You were in Laguna.
I was in Laguna Beach, and she lived in Simi Valley. And, you know, I mean, you know, it was very hurtful. I mean, it basically... The only good blessing of it was that it basically cut off any love I had for her whatsoever.
So you got something out of it.
I got something great out of it. I was able to move on.
Isn't that a payoff?
Oh, it was a beautiful payoff. It was the turning point of one of the turning points of my life.
Look, the payoffs don't always have to be in money.
I hear you.
Satisfaction is the greatest payoff.
Amen
Truly,
to that.
it really is true.
I agree.
When I started to write the book, for example, my wife said to me, "Why are you writing this book? Is it for yourself? You're going to sit down and read this to yourself?" I said, "No, I'm really doing this because I want to share my knowledge and my experience with other people, and maybe it'll help them steer through or navigate through the system." I mean, that was the purpose of all of this, as a matter of fact. So let's get on to the hypothetical.
Okay.
The hypothetical is...
What's hypothetical mean?
It means you assume a lot of things.
Okay, I'm going to assume a lot of things.
So you assume that there's two cars.
Two cars.
Two cars. One, they're coming perpendicularly to the intersection.
Okay.
And there's a traffic light, right?
Mm-hmm.
And they crash. So one party, the plaintiff, sues the other one, said that they passed the red light. The other party says, wait a minute, I didn't pass the red light, you passed the red light, and you hit me in the intersection. So while the plaintiff sues the defendant files what's called a defendant's claim against the plaintiff. Now we're talking about small claims court.
Countersuit type thing.
Countersuit,
Okay.
cross-complaint,
Right.
counterclaim.
Whatever you want to call it.
And so they're in court, and there's no lawyers, right? There's no pictures of the scene. There are no witnesses, no eyewitnesses at all. But each side, presumably they had insurance, but the way they normally handle these, by the way, if both parties are pointing fingers at each other, is the two insurance companies, assuming both have insurance, will usually mediate it or arbitrate it, and they resolve it between them. But this didn't happen in this case. The plaintiff was asking for $10,000 for the personal injuries that she had in the accident, and she had medical reports, but she also had a report from a biophysical person, a biomechanical person, who said that based on physical evidence, just the physical evidence, he concluded that the accident was caused by the other party. Well, not to undo the other party, the defendant and now cross-complainant, they had their own expert who came in and said, look, based on the facts, there's no witnesses, there's no pictures, there's no nothing. Based on these facts, I think the other side did it.
Did they come into court? These?
No, they didn't. They had reports.
They had reports. Okay, they had reports.
Because
okay.
they could have brought him into court.
No, I'm saying I know that. I know in small claims court you can actually have witnesses.
You absolutely can.
Yes,
it's not usually done because it's an expense.
Right.
You have to pay these people.
Yeah.
And from the discussion we had about personal injury cases, the plaintiffs hire their own person from the list of people that they use on a regular basis. It's the same doctors. It's the same, and it's the same group.
Right.
And especially with a lawyer that has a big, what we call a personal injury mill, where that's all they do all day is personal injury cases.
Got me $10 million.
Yeah. On the billboard, I said, I'm going to call that guy.
Yeah, exactly.
I was going to call and ask him, tell me about that case. You're not going to get a straight answer.
No.
But it doesn't matter.
Anyways.
But this is what they do.
Okay.
And to make it equally dishonest, the insurance company people, they do the same thing. They got the same list, different people.
Right.
They make a living off of working for the insurance companies, and some of the insurance company doctors will find nothing wrong with you if you come in on a gurney. I mean, that's the way the business operates.
Yeah.
You pay yours, they pay theirs, and it's left to the trier of fact. Now, you are going to be a jury of one today, Gary.
Oh, boy.
And so I listened to both sides.
Okay, you listen to both sides.
She was convincing, and he was convincing. It was one was a woman, and the other was a man. And
was she hot?
I guess it depends on your point of view.
On your point of view, was she good looking?
My point of view, it makes no difference.
Okay.
I can't say I don't look.
Of course you'll look.
But the reality is, I heard the case.
Okay.
And
these are all the factors you're giving.
Yeah. The important thing is no witnesses.
No witnesses.
No cameras. It's just the word of the plaintiff and the word of the defendant and the cross-complainant. Okay? That's all you got.
Okay.
So now, good, the commercial comes along at the perfect time.
Now I can ask him what he ruled on.
Now you can think about it. I'm not going to talk to you off the camera.
Oh, that's thanks.
No, you're getting no help.
All right, it's for the people. Judge Herb Dodell. Get his book From the Trench to the Bench, now available on Amazon.
And you could even ask me questions, and I do respond. I did to the lady last week.
You did.
Go to askjudgeherb@gmail.com.
I'll say it for you after the break. Okay, hold on.
Okay, sounds good.
50 a.m. KCAA.
Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, he has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system, so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, I left out an important fact.
Oh, thanks, Judge.
It's not a fact. It's the law.
Okay.
Because you have to apply the law.
Okay, thank you.
We really do apply the law. And there's a law in California, and it's probably in most states. Sometimes it's called contributory negligence. In some places it's called comparative negligence. What it means is if you find that one party caused the accident, but the other party contributed to causing that accident, either they were slightly negligent or negligent in some degree, and what you do is you take the amount of the award and then you apply the percentage of negligence from the party that won, and you offset the amount of the award by the amount of the contributory or comparative negligence.
So it could be 60-40 or 70-30 or
The case is
whatever.
called Lee versus Yellow Cab. That's an old case in California which decided about comparative or contributory negligence. So given that fact too, now you have a third possibility. It's a plaintiff, a defendant, or it's a plaintiff who gets some but not all. And they're both asking for $10,000. They both had medical bills. They both went through the same kind of operations, not operations, you know.
I know they went through the
went through the same
therapy,
process.
They went through therapy.
They did the
all
3
that.
months, the usual drill.
Right. Mm-hmm.
And they were all represented by lawyers at the time who bailed out, of course, at the time of the small claims court hearings, which is what they do. Okay. So given those facts now, what do you think the decision should have been?
Well, I'm always going with the hot chick, but you know.
I threw that. I threw the one was a girl in there because I figured that might.
All right, hold on. I'm joking. Okay, so what I'm thinking is this. Okay, you said it went perpendicular, so they ran into each other at the intersection.
In the intersection.
In the intersection. Bam.
Yeah.
I would sort of base it. And was there pictures of the car?
No.
No.
Oh yeah, there's pictures of the car.
Pictures of the cars.
Yeah, well, that's what the experts relied on.
That's what I'm saying. So, personally, this is what I would do. I don't know. I would sort of like maybe think about that intersection and see where the person ran into each other. You know.
There are measurements, by the way, because when the police come out, one of the first things they do is they measure. They got this little stick that they walk.
I look at the police report first off.
Okay.
Okay, that's the first thing I would do.
Police report says the officer has no idea, got after the fact, and can make no determination.
They could make a
either way.
determination on this. Okay, well, there you go. I'm throwing that. Then I got to throw that out.
No, that's good.
All
There
right.
was a police report, and it was one that said they couldn't really tell.
Okay, so they couldn't tell. All right. So,
But you had the pictures that were taken at the scene, and those were considered by the experts for both sides.
Okay, and you gave one person more than the other.
I'm going to tell you what the answer is after you tell me what you think.
I would say they're both negligent. If the police officer couldn't tell, it wasn't in the police report. They both had the same type of damages, same sort of physical damage. I would say it was probably they're both at fault, and I'd split Split the baby, as they say, 50-50.
Wrong.
Okay, well, that's how I'm just throwing.
No.
You
Look,
asked
the
me.
purpose of the story and the hypothetical.
I told you I'd take the hot chicks. So 70-30.
That's why I like doing the show with you, Gary. I'm always going to be throwing something interesting.
I'm a simpleton.
Well,
what can I say?
no, but the reality is that you have to apply a principle of law that's, I think, in fact, I say so. When I take the bench, I always say this to every audience, every time.
Who's more believable?
No, it's called burden of proof.
Right.
Now, if you're making a claim against the other party, you have the burden of doing several things. One, you have to prove that they were legally responsible, and two, you have to prove your damages.
I know,
Those
but
are the two aspects.
I know, but didn't the other party countersue?
Yeah.
Okay, so I mean, don't they have a burden of proof too?
Yes, they do.
Okay, so you got
Yes,
two burdens
they do.
of proof.
Both parties have a burden of proof.
Right.
Now, the plaintiff has the original burden of proof because they started.
So you get that more weight.
So you now decide it basically as two cases, right?
Yeah.
So the first case, the plaintiff puts on their evidence.
Right.
They bring in their expert. The defendant's expert is the refuting of that testimony. That's the cross-examination. But even though there's no cross-examination in small claims court, it's cross-examination by using documents and photographs and things like that. So that's cross-examination of a kind.
Yeah.
And so
you broke it. So hold on, you broke it down into two different cases then.
Sure.
Okay. That's
First case, the plaintiff win? No. Why
Okay.
not? Couldn't prove liability.
okay.
You have a dispute of two experts. You could say expert number one was more believable if you want to, and if that's true, that goes to the weight of the evidence that you're considering, and it may be enough to prove that the plaintiff is right, that the defendant caused the accident. Maybe. But if both experts, and you know exactly where these experts are coming from, I've seen
Well, they're getting paid.
everybody's got their own motive.
Of course.
And so the bottom line really is, how credible was one witness, expert witness, versus the other? How credible are the two parties talking to each other? If one said, look, I only had 3 drinks before I got in the car, that's going to make a big difference.
Of course.
There may have been, it's a good likelihood that person was impaired.
But you're saying there was this, it was completely even. Everything was equal.
Everything's equal.
Okay, well, I would probably just thrown out the case. Give them nothing. Each of them nothing. I mean, that's how I would have done it.
What about comparative fault? That maybe someone was partially responsible.
I don't think I would do that. I would base it on the police report. If the police officer couldn't determine any person as the guilty party or responsible party, whatever. If he can't do it, and then you have everything equal, and they both seem believable and everything's, I would just say, hey, you know what? It's done. Get out of my courtroom.
It's done.
Leave me alone. I got to go to lunch.
We get an hour and a half for lunch, so it's not a big deal.
I'm meeting my buddy for sushi.
Okay.
What did you do? I don't know. I mean, you tell me. I don't know.
I'll tell you what I did.
All right, tell me what you did.
You were right on your ultimate guess. I ruled against the plaintiff on the plaintiff's case because she didn't satisfy the burden of proof.
Right.
And what is the burden of proof? By a preponderance of the evidence. And that definition, and I'm mentioning it now because it's important to keep that in mind, is called preponderance of the evidence because it means more likely than not. So if you stay at the end of the case, if you say to yourself, as the trier of fact, I'm not sure, party with the burden of proof loses. Can you tell what that's going to be in the beginning before you start the trial? Absolutely not. Neither side knows where it's going to go. Maybe the credibility of one expert is going to be greater than the credibility of the other, and you don't know if your expert's going to be the better of the two or not. You don't know that. So what's the answer to the question? First, let's get to the question. What should you do? Settle the case.
Right.
Because you run the risk that a judge is going to do exactly what I did, give you nothing.
Right, you did nothing.
I gave him nothing.
Exactly.
And for the cross complaint,
that's when I said split the baby. I meant they get nothing. It was like forget it. That's what I meant.
Okay, well if that's
I didn't say it correctly, but that's what I meant.
If that's what you meant,
I was going to throw it out.
If that's what you meant by splitting the baby, then you're right.
Yeah.
The same thing for the defendant. The defendant becomes the plaintiff.
Right.
Because they have a separate case. They're molded together. They're consolidated. They're tried together. Generally, they are if the facts are the same. Sometimes cases are severed when both parties sue each other because the facts are different. But in this case, same course of events, everything was the same. So for the defendant who got sued, filed their own lawsuit, he had the burden of proving that she ran the red light and caused the accident, and he was blameless.
Right.
Or at the very worst, he took his eyes off the road to look at a dog, whatever the story may be. There wasn't such a story in this case. It was relatively simple. But I looked at the two reports, and I've seen this so many times. Each expert's got their own story.
Yeah.
If you got an injury case, the plaintiff's got them taking shots and sick, sore, lame, and disabled for the rest of their lives. It's like that old thing, how hard could you raise your hand before the accident,
Yeah.
and the defense, if they send them out, the defense sends them out, usually the insurance company.
Right.
The defense sends them out for what they call an IME. They call it independent medical exam. Those of us who are on the plaintiff side, I've done both actually, they call them insurance medical examination, because there's nothing wrong. These people will be found perfectly, either they had it before or they don't have it at all and never had it before.
Right.
I mean, so you get the defense doctor comes in, and I used to go to these examinations under oath, these medical examinations with a court reporter, with the defense ones, because the doctor doesn't come in, somebody else takes the history.
Yeah.
The doctor comes in, he or she is going to be there for a minimal amount of time. They're going to run through the same usual tests, and they're going to conclude there's nothing wrong with this person. This is the way it works. So I would time it. The doctor was in there 4 minutes.
Right.
He didn't do test A, B, C, D, and A, because if you've studied this subject, you know what various tests mean and what they should reflect if they're done properly. And so the defense person writes it off. The plaintiff says horrible injuries, permanent, life-threatening, whatever it is. And
Golf game is screwed up now.
Don't be surprised.
Oh, I know.
Don't be surprised.
I trust. Trust me. I know.
Did I tell you this story? I got a great story. Let's get finished with this first.
All right.
And so the bottom line was the defendant, cross-complainant, he couldn't prove it either. He couldn't satisfy the burden of proof by more credible, more likely than not. So he get nothing either. And neither of them get costs because each of them lost.
So they had to pay the experts and all that?
I'm sure the experts are paid by the insurance companies.
Okay. All right.
And you know what? No appeals for anybody in here either.
Well,
Is there? Well, I guess there might be an appeal. Not really,
how could they?
because both defendants prevailed.
Yeah, they both won and lost.
Defendants prevailed.
They won and lost, right?
Well, yes, that's true, but the plaintiff didn't win. The plaintiff basically didn't lose either.
Right.
They just got nothing.
Yeah.
So the bottom line was everybody walks away without anything. They should have settled that case. They could have worked it out. Like you said, they probably could have split the baby, because the biggest problem with all of these cases, all of them, is you don't know the outcome. You just don't know.
Well, I mean, especially with the police report, I mean, that's what my whole basis would have been on it. When you asked me the question and I asked you about the police report, if the police officer doesn't know and says, hey, I don't know who's at fault or what, because these guys do this stuff all the time. They're experts.
They are, but I've seen a lot of reports where they might take a position supporting one of the two parties. Does that mean you give credit to that report and that officer's conclusion? He's never been cross-examination. She's never been cross-examined. You know nothing. They showed up 10 minutes after the accident. Everybody's sitting on the side of the road by then. They run the little thing in the middle of the street. They make measurements.
No, I understand.
How do you justify that conclusion just because it comes from a police officer who doesn't have any we call it foundation.
Yeah.
There's no foundation for the opinion.
Well, I mean, the reasons I'm saying this is because you said everything was equal.
I made it everything equal. Well, everything was equal.
Yeah, so that's why
because it makes it a lot easier case. If there's a factor, like there was a camera and you could see it, it makes a big difference.
Yeah.
KCAA Loma Linda, 1050 AM, K292FQ Riverside, and K293CF Moreno Valley.
Yeah. You got one expert and not an expert from the other side. Makes a difference. You got the officer comes out, and there was a witness on the corner at standing in front of the liquor store who said, I was standing there minding my own business taking a swig, and I looked over there, and boom, this guy whacked right through the light, and he hit her right in the middle of the intersection. You get those.
Right.
There's lots of different variances. So after the break, I'm going to tell you a great story about how we settled the case, which I'm still chuckling about after 30 years.
Okay, we can't talk about Stormy Daniels.
We can talk about her.
All right, it is for.
Oh, I think that's so fascinating.
We got to talk about that.
I
All right,
love that. What's going on there?
let's do it. All right.
It really makes the lawyers think.
All right, we got to take a break. It's for the
Okay.
people at Judge Herb Dodell. We'll be back after this.
DC Talk Radio, 1050 AM, KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal system. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
So I just want to wrap up this point by mentioning this term again, burden of proof. If you go to a trial anywhere, the first question you have to ask yourself is, can I prove it? What evidence do I have to prove it? And what evidence do they have to disprove it? Or just to create, even though doubt is a relative term, and reasonable doubt is the criteria used in criminal cases, not in civil cases. Doubt is enough to decide a case. I have doubt who to believe. Burden of proof was on the party. Party didn't make the burden of proof. End of the case. So here's the case. I love this case. It was really fun. I remember I had an office on Sunset Boulevard. I'll never forget it.
How long ago was this?
At least 30 years.
Okay.
At least 30 years.
So I was
And times have really changed. So the outcome here might not be the same today as it was 30 years ago. But here was a person comes in, was in an automobile accident, was working for the county, had a nice job, and he claimed that at one point he was in this accident and he was damaged. He didn't have big medical bills, but the person sitting across from me, the man I just mentioned, was now a woman.
Wow.
And she was transgender.
Yeah, transgender.
Those days, and it's interesting, it goes back probably more than 30 years.
Wow.
I once represented a urologist, and he used to do the sex transplant changes.
Oh, man.
So he would refer all of the transgender people to do the name changes. You know, little stuff in the beginning.
Yeah.
There was little technical things. So I represented the International Transsexual Union or something. A client. So I had this person came in.
Yeah.
And didn't have major medicals, nothing. So I was talking to the insurance company. They said, yeah, we'll give you 2 times the specials. That means we'll multiply the medical damages by 2, and that's what we'll settle it for. They were those days, the adjusters were paying 2 to 3 times whatever the medical bills were. And the way it worked out was the lawyer who was working with the doctor's medical bills would end up getting negotiated down, and the lawyer would take it. They do lots of little routines that these people would still do.
Right.
Still do.
Yeah.
I mean, this is a cottage industry that has all kinds of relationships. Let's put it that way. I'm going to call it kindly relationships.
Yeah.
So I call the insurance company, and I said, I have a unique case here. He said, what do you mean? I said, well, he was working and as a result of this trauma that he was in this accident, it triggered off some latent feelings that he had that he really wanted to be a woman. He was married.
Oh, Judge.
He was married. I said, this triggered a change.
You really did this?
I really did, and I got $50,000.
Oh, my God.
I remember that because it was a policy limit. The policy limit for the other side. And
they bought that?
They did.
Damn. That's
They were
crazy.
afraid. They were taking a chance.
Right.
And in California, if you know what the policy limit is for the other side, this is some good, valuable advice for you folks out there listening. Find out what the policy limits are. Let's say it's a $25,000 policy, and you make a demand for the policy. I want the $25,000. If they don't give it to you, they've exposed their insured, people they're insuring, they've exposed them to whatever the damages are that's in excess of the policy.
Right, higher.
You could hit 100.
Right.
And it's happened many times to me over the years where you make the demand, they're not going to pay it, they don't pay it, you go to trial, because you have to go to trial at some point. You go to trial, and they know who the trial lawyers are versus the non-trial lawyers. You always kid around by mentioning a couple of names. I'm not going to repeat them here. Those people don't go to court. Those people probably have never been in court.
Right.
They marshal up the numbers, they write the letters, and they settle the cases. 90-some-odd% of the cases settled anyway.
Yeah.
So that's what they do. And they work out whatever deals they need to work out. So if you ask for the 25 and they don't give it to you, and you go to trial, and they know you try cases because you're a member of organizations like ABOTA, which I think I've mentioned before, the American Board of Trial Advocates. If they see that you're a member of ABOTA, now they run your name through Google and whatever. They know you know what you're doing because you didn't get invited. It's an invite organization only.
Yeah.
You got to be invited by your peers. You have to have tried a number of cases. You have to be vetted and all of that other stuff.
Right.
They know who the guys are and the gals are who try cases. And it's not the guys and the gals who put the signs on the back of the buses. Generally not.
No, they don't
So
do that.
you ask for the 25, they don't give it to you, and you go to trial and you hit it for 50. They could be stuck for the whole amount because now you've got a judgment against this insured for $50,000. They'll pay the 25 because they're obligated to.
And then the person's has to pay the other 25.
And they go after their insurance company.
Oh, man. Wow.
That's what's called bad faith.
Really?
I made a living doing that for many years, suing for bad faith against insurance companies. That's what I did. And the reality is that they're stuck for it. It's the same thing with underinsurance. I don't know if we never discussed underinsurance, but sometimes you have an insurance policy that covers a situation where the other party that causes the accident doesn't have enough insurance to cover your damages. Well, you can recover that from your own insurance company. It's called underinsurance coverage. So they are watching to see what you do with that third party, because if you settle it for the policy limits and it's a reasonable settlement, there's no underinsurance. So the way you frame the resolution, the releases, the documents, and whatever is very, very important. Very important. I had a case many years ago where there was a $50,000 policy. The insurance company for the party causing the accident was willing to pay it. They did. I went against the underinsured insurance company, and it was a finger injury.
Middle finger?
Might as well have been, because we gave them the middle finger at the end of the day. But that's a good lead-in. We gave him the finger at the end of the day. But it was a question of whether, and he was a dentist.
Oh, really?
So the argument was, he was really damaged in his occupation because that finger that he used to hold the mirror or whatever it was.
Drill,
At the end of the day, he had pressure on his finger.
Yeah.
We got $185,000.
Wow.
From his own insurance company, less the $50,000 that he got from the party that caused the accident. So you really want to know, number one, what policy coverage you have.
Right.
Have somebody look at your policy. Have your lawyer look at your policy. What do you got? You may even have what they call uninsured motorist. The other side doesn't have any insurance at all.
Right.
Then it becomes a claim against your own insurance company.
Right.
And they have a duty to you to pay you the reasonable amount as though they were a third party.
Yeah.
They don't do that, you're setting them up for what's called bad faith. And it happens in large numbers with construction damages and things like that.
Workman's comp.
Comp is a different world.
Different thing. Okay.
I don't want to denigrate the comp lawyers too much, but their business is a lot more simple than just about everybody else.
Okay.
Everything's on the chart on the wall.
All right.
The doctor says you're 10% damaged or 20%. They take the number. That's the number.
That's the number.
And it's
the damages.
It's a volume business.
Okay.
If you talk to a comp lawyer, they're down at the comp board They may have 20, 30 cases at a shot
Wow.
because that's all they do. It's all a multiplication.
Yeah.
That's how you get.
So they don't
paid.
go to trial really or anything like that.
You can.
But I'm saying normally they don't. They just settle.
No, it's the same people.
Same thing. Okay.
The defense lawyers are usually the same people
Right.
that are there all the time. They work for the insurance companies, the comp insurance companies, which are different than the usual liability insurance companies, usually. And then you get the plaintiff's lawyers who just run it up because you see it's really no fault.
Yeah.
See, normally when you have to prove liability in a case, you're suing a third person, you have to prove that they were liable, they did something, they were negligent or did something. Not in workers' comp. Workers' comp is no fault.
Yeah.
Like no fault in New York. You don't look to see who caused the accident. Insurance company pays, and that's the way.
And that's it.
That's it. And in comp, the numbers are much lower. That's why you don't want to have a comp case. You want to have a third-party case because you're not limited to the percentages. And that's what I did when I sued Hugh Hefner.
You sued Hugh Hefner?
I did. He was a nice guy.
Why'd you sue?
I took his deposition, actually.
Why did you sue Hugh Hefner?
I represented the cook, the chef at the mansion.
At the Playboy Mansion?
Yeah, and he was coming out after a day's shift, and he got bit by the guard dog. On his
I
lip.
thought he got bit by a bunny.
You know what? I'm stumped for that one.
Sorry,
He got bit by
Judge.
the dog.
Okay, he got bit by the dog.
So
I didn't know
they
there was any dogs up there.
They
They're
had
all...
a couple of guard dogs.
Did they? Okay.
Yeah.
All right.
So the bottom line was we sued him and the Playboy Mansion and everything else, and their defense was workers' comp. He was working. And we found an exception. This is my law clerk who was on the job maybe a month, and he found an exclusion, an exception, that if you work a certain number of hours a month as a domestic, you're not covered by workers' comp. So I went after Hefner personally. Set his deposition. He didn't show up.
He didn't show up.
Didn't show up. I go down to court and I make a motion to compel him to show up.
Right.
They grant my motion. They gave me some sanction money because he didn't show up and ordered him to appear at where I wanted him. So they called me from the insurance company for the Playboy Mansion. Said, why don't you come up to the mansion? I said, you know what? I was in showbiz. I don't need to go up to the mansion.
Oh, come on.
I did. I told him I want him here 5 o'clock on a Friday.
Right.
On Sunset Boulevard, right in the middle of the traffic.
Oh, just drive him nuts.
He showed.
Yeah.
He showed up with a 6-pack of Pepsi, and his lawyer was a nice guy.
His robe, too?
No robe.
No robe.
He came unclothed.
Oh.
No, but he was very good. He was a very nice.
He is a nice guy.
He was very nice.
He's a very nice
So
guy.
as he was leaving, I said to him, I hate to see you going to spend 3 weeks in court. And he looked at me and I looked at him and I said, nothing personal. He's, I know this. I know where we're going here. I settled within 2 weeks.
Did you?
Yeah. And I bought a house.
Wow.
It was a very good settlement.
I bet.
I bought my first house.
Wow. Off of Hugh Hefner.
Yeah, off of Hugh Hefner.
God rest his
I
soul.
got great stories.
I know. Well, these are great stories. This is the first time I heard of this.
It was somewhat imaginative, and I thank the lawyer that was working for me. He's a very good lawyer. He's an outstanding lawyer. Now he was trial lawyer of the year last year, I think, or 2 years ago. And it was his first job. He was working for me, and he found this exclusion. I said, wow, it's the difference between getting 10% of minimal amount versus what we ultimately got. So
how much did you hit him up for?
I don't really remember. Enough to buy the house.
Okay.
It was 6 figures. Because,
really?
Well, yeah, I had to make a big down payment.
Damn the judge.
So I did it. It was great, and it's great because it's a great story.
It is.
It shows you have to be imaginative and you got to be aggressive. And when we talk about picking lawyers, you should get that kind of read off of who it is that you're interviewing. Is that person going to be aggressive, or are they just going to roll up the numbers and make a couple of phone calls and write a letter? You don't want that person. Anybody can do that.
Yeah.
And so part of the interviewing process is and it's okay to listen to some stories. Ask them what you've done before, how many times you've been in court.
Have you sued Hugh Hefner?
Have you sued anybody? That's why it's interesting. This whole Stormy Daniels thing is fascinating.
Yeah, we got to talk about this.
It's fascinating.
This is crazy.
I love the facts in this case.
I know. Every time I hear about it, I always want to talk about it with you. You know what I mean?
Well, it's the same thing in any case. Nobody knows what some judge is going to decide. if they void that agreement, and I kept saying to myself, how do you have an agreement with the different person's name in it and it's unsigned?
Yeah.
You know, that makes it pretty hard. If it's Donald Duck versus Mary Jones, and there is no such people, how do you have a contract?
Yeah.
You know?
I call him Daffy Duck, but that's okay. All right, it's for the
you
people.
You can call it any way you want.
It's for the people.
Write to me. Contact me. I'll get back to you.
Ask Judge
I'm gonna
Herb
try. I'll
at
try.
gmail.com. Ask Judge Herb at gmail.com.
1050 AM, KCAA.
Did you ever meet a lawyer that was for the people? Someone who had the best interests of the people at heart? Herb Dodell has been a lawyer for more than 50 years and has been a Superior Court judge for 9 years, having presided over more than 9,000 cases. In this show, he will reveal the secrets of how things really work in the legal system, so you can maximize your position and benefit most when you're in trouble and need someone on your side to simplify the process for you. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Keeping in line with what we've been doing, like current events, I understand. You just told me that President Trump countersued her for $200 million.
Yeah, he's just countersued Stormy Daniels for $200 million.
Bad choice.
Why is it a bad choice?
In my opinion, no, I'm only talking.
No, I'm just asking. And
I don't know. I don't know enough about all the facts to say so, but I'm assuming that she's won her first little skirmish, because they have not enjoined her from, or the network, whatever she's on, CBS or something.
She's going to be on. She's going to be on 60 Minutes this Sunday. The interview with her is going to play on 60 Minutes this Sunday. So I guess he's suing her because
defamation.
Right, for defamation.
Defamation in California is a very anywhere. It's a very different, what they call a cause of action, and that's what I want to talk about. The second part, we don't have much time to do it. But people are saying bad things and doing bad things, and then they say, well, I want to sue you for defamation. Well, in California, and probably in other states, maybe not, there is something called a slap motion. Not the slap you're thinking about. It's SLAPP. That means the California legislature passed a law that says you can't sue somebody for saying bad things about you if they're petitioning the government or they're making comments or things like that. You can't sue them for that because they're exercising their rights of free speech and free assembly, and that's called an anti-slap motion. The defendant now files what's called an anti-slap motion. And if the defendant says, look, all I was doing was taking an ad out, I was giving him my opinion about such and such, and that's in connection with my right to make free comment, that case is over. The complaint is stricken, and the defendant who got sued can recover attorney's fees. It's one of those few instances where you can recover attorney's fees because you beat that complaint. The complaint is stricken.
Yeah.
On the other hand, if you lose that, the case just goes on. Now, a plaintiff that loses because it's been stricken may be liable for those attorney's fees. On the other hand, not may, will be responsible for the attorney's fees, but may also, if the motion is denied, and it looks like the motion was made frivolously to stall or whatever it is, and there really was no merit to making that motion to strike it, then the plaintiff, under those circumstances, can recover his or her or their attorney's fees as well. So it's one of those cases where you got to be careful what you're suing for. Yeah. Defamation is a tough one.
I mean, what's your definition of defamation?
Well, it's a statement that's made that's not true, has to be not true, made with the intention of causing harm to some other person, and is beyond your right of comment. Like I ate in this terrible restaurant, the food was awful, and the portions were small too. You know, so nobody seems to laugh at it. I love that story.
Sorry.
Somebody goes into a restaurant and says the food is awful, and they give small portions. I mean, the bottom line is those are called slap motions or anti-slap motions.
Well, I mean, people do this on Yelp, though. They give.
You're entitled to.
I know, but so that's not defamation.
No.
Okay.
It's not.
But defamation, I mean, let's say, is that something that would harm somebody? Like,
yes, it was
monetarily or physically or
both. Emotionally, too.
Emotionally, okay.
I was talking to somebody just before I got here, as a matter of fact, today. Said, the economic damages on a case are what they are. You lost so many dollars, you missed a deal or whatever it may be. And in non-contract situations, tort situations, people suffer from emotional damages. Being involved in a lawsuit is devastating to some people. I had clients over the years who couldn't sleep for years. Yeah. They looked a little seedy with the beard and everything by that time, but the guy said, I'm sleeping for 46 years. You remember that?
Rip Van Winkle.
Well, he comes from where I come from. I come from about 10 miles from there, 8 miles from there.
Yeah.
So the bottom line is that defamation and any kind of tort can cause you emotional damages. In fact, the restraining order section in California is basically to prevent people from being harassed. Stalking is harassment. Threats are harassment. In any lawsuit where there's a tort involved, you can, as the victim, recover for your emotional damages. They don't necessarily have to be physical.
Should have sued my ex-wife.
And get your $50,000 back.
I'd take 10.
You're always eager to negotiate.
Of course. You told me to negotiate.
But I was mentioning I had a client who seriously for years couldn't take his every day.
I'll tell you.
All he could think about. He would call me all the time.
I'm sure. I mean, even when Baldy the Clown sued me, it went on for like a month and a half before I went to People's Court, but I was losing sleep over it. It was disturbing me. It was during the holidays and during Christmas and Hanukkah and all that and the New Year, and it really upset me.
It was tough for him too. He grew hair.
He got a wig.
I know you told me he was wigging out. That's what he was saying. He was going to sue you for defamation. And by the way,
he tried to get a restraining order against me too. It was a whole thing. The guy was vindictive. But whatever.
But I've said this since the first show, and I'm going to continue to say it for those who haven't heard it before. Small claims court is the place to be most of the time. You can sue somebody for defamation in small claims court.
Oh, you can?
The rules apply there too.
I didn't know that.
I suppose one could. I've never seen it. I have never seen it. I suppose one could, if they got sued for defamation in small claims court, they could probably raise the anti-slap and saying I was just giving my opinion. I can give my opinion. Opinions are not actionable as long as it's an opinion.
Yeah.
I ate in this restaurant and I hated it.
Right.
You can't do anything to that person.
Yeah. That's your opinion.
To say, look, I just bought this car and I don't like the way it drives. And you walk in front of the dealership with a picket sign.
Yeah.
It's okay. Yeah. As long as you don't keep people from getting in and out of that place.
Right.
Picketing is one of the first examples of the opportunity and the blessing that we have in this country, which makes it so great.
First Amendment, right?
Yeah. Why is it called the First Amendment? Because obviously it was on the minds of the forefathers when they were thinking about what are you going to put into this thing called the Constitution. It was the right to speak freely, to assemble.
Right.
Because remember, in the beginning of the revolution, on almost every revolution, you see the people in the street walking with signs and
always
doing whatever it is. And that's to be protected. In our country, it's protected. Some other places, they mow them down with water cannons. But here, we're tolerant because we should be tolerant.
Yeah.
But it doesn't mean you could sue everybody for every little thing. If you got a little beef and it's under $10,000, which is the California limit for individuals, what you do is you bring it in small claims court. You tell your story. There's no lawyers, and my feelings are hurt. Why are they hurt? Because they did all of these things to me, and so I've been to a psychiatrist, and I'm taking pills now, and all those things. Those are recoverable, if they're related. It's called proximate cause, or known as legal cause. You have to show that they're connected. You can't say, okay, well, I now have migraine headaches. How long have you had them? Oh, 43 years. You can't
I've been
It's gotta
drinking
be
a
connected.
12-pack. I've been drinking a 12-pack instead of a 6-pack.
That's right. And you know what? You know what? That might work.
That might work, really?
You know, we don't have any juries in small claims court. You have a jury of one,
Right, you.
right?
You.
Me or whoever's sitting there.
Right.
And again, you don't know what that judge is going to do.
Yeah.
And if you think that you got a shot of losing it for legal reasons, technical reasons, or just any reason, sit down and settle it.
Yeah, it is very stressful. I mean, you know, all kidding aside about, you know, me being sued, I mean, it was very stressful. And luckily, I did it in people's court where they pay for whatever decision happens. Like if I would have lost, they would have paid the damages, you know. So it took the burden off of me. But if I had to go to Superior Court and be sued for $10,000 in small claims, I mean, luckily it didn't go that way. But it's stressful, man. I don't care you getting sued for $2,000. It's a stressful thing.
Look, I often ask the question to people. They're standing in front of us, you know, putting on their case, and I sometimes think I could see some of them shaking.
I'm sure.
And I had one collapse. They fell out right to the floor.
Wow. And
we had to bring in they came in with the paramedics and everything else.
How'd you roll on that one?
I gave her continuance.
You're all hard.
But the fact of the matter is, people get very nervous in that court.
Of course.
And
it's intimidating.
It is definitely intimidating, especially if you've never been there before.
Exactly.
And you got a guy walking around with a gun on his hip.
Yeah.
And in our court in Ventura, we try the cases in Department 36, and that's sometimes it's used as an arraignment court. So we have a cage for the prisoner, for what we call the custodies.
Yeah.
And so it's it's in that room. So I say to them, I always kind of jokingly said, you know what? If you misbehave, you're going to get a new seat. The seat is going to be over there.
You really say that?
I do say that.
I hope you say it with a little twinkle in your eye.
I do more than a twinkle.
All right,
I'm only kidding. I'm only kidding.
All right, I hope so.
But you got to behave yourself. And every now and again, somebody doesn't behave themselves. They really don't. People get very emotional.
Of course they do.
They get emotional because they're really putting their own credibility on the line. Some of them, it's really about the money. And I can sometimes sense that. That they're only there because they're trying to get. I've told you some stories that people have filed lawsuits. It's only about the money. The lady with the cheese.
Yeah, well, what about
the lady with the cheese?
I heard. What about Baldy? I mean, you know, he just wanted the money too. I mean, I never made a deal with him about getting paid on this show, on my show. It's ridiculous. It was ridiculous.
To some, they know the other side is not going to show up.
Yeah.
If they know that. If they don't show up and I grant the judgment in favor of the plaintiff, it's not appealable by the defendant, even if they lost, because they didn't show up.
Right.
They could make a motion to vacate it on the grounds that they were in Cincinnati at the time and they couldn't have been served or whatever it is. And then it becomes a battle between them and the process server who has to be there.
Right.
And so the bottom line really is they can appeal from a denial of the motion to vacate, but they can't appeal from the judgment. And to get a $10,000 judgment against somebody, collectible,
yeah,
puts that defendant in a big spot.
Absolutely.
So they have a lot to lose, and that's why some of them come there. They bring witnesses. I have seen folders. People come in with these binders,
right,
with pictures and indexes and whatever. I got 10 minutes.
I hear you.
I don't have a chance to go through all of it. You got to highlight a piece of advice for people in small claims court.
Yeah.
Highlight your strong point. Make a copy. Make it big enough for me to see. Make sure the other side has a copy before you start the trial. I won't consider it if you haven't shown it to the other side. I always tell people there's no trial by ambush here. You got to show them what you got.
Right.
So today we showed you what we got, giving some advice. And I also want to tell you, anybody who's interested, I'm going to try this. I'm going to give you what's called a case citation. If you want to know more about anti-SLAPP and how it really works in defamation, the case is Flatley, F-L-A-T-L-E-Y versus Mauro, M-A-U-R-O. You can go on Google, print it. It's a long opinion, but it's very comprehensive. It's a Supreme Court California opinion. And I'll tell you all about when you get sued for the wrong reasons. So give it a shot. If you want to read more, or write me and I'll try to respond to you.
All right. It's and by the way, if you want to write or email Judge Herb,
you can.
It's askjudgeherb@gmail.com. That's askjudgeherb@gmail.com. Get his book From the Trench to the Bench on Amazon. And also, YouTube videos.
YouTubes, that's right.
We have YouTube videos.
The real question, Gary, is were you distracted by this fish swimming in the background?
I love your fish. They're so
They
cool.
like you too.
I know.
They swim right to the front when they see you.
I'm an animal lover. What can I say? All right. Judge, great show.
We'll see you next week.
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM. Psst. Hey, you. Yeah, you. Do you know where you are? Well, you've done it now. You're listening to KCAA Loma Linda, your CNBC